talking about it and freeing my mind. For others, is that I want to see the perpetrator in jail. For others, I just want to hear the perpetrator tell me I am sorry.
Good day, viewers. Welcome to another session of Justice for You. My name is Eunice from Edward Foundation, an organization that renders free legal services to indigent and innocent inmates here in Nigeria. Today, we'll be discussing on the effects of COVID-19 on prison inmates. And I have here with me Barrister Eboluwa Adetiba. You're welcome, ma'am.
Thank you very much.
Please, let's meet you, ma'am.
My name is Eboluwa Adetiba, Managing Partner of the Brookgate Chambers, a firm of seasoned legal practitioners based here in Lagos, and our core areas of practice, courts across criminal litigation, civil litigation, and other areas of law. And we have been in practice for quite a while, and I think we have a relationship already.
You're welcome, ma'am.
Thank you.
So today we'll be discussing on the effect of COVID-19 on prison inmates.
Yes.
COVID-19, known as coronavirus, has affected a lot of businesses, even our day-to-day activities are not the way it used to be.
Yes, absolutely.
So in what ways can you say the COVID-19 has affected or is affecting prison inmates?
The COVID-19 is affecting the prison inmates in ways that we can't even imagine. Number one thing is the prison is congested. They cannot maintain or keep social distance. All the facilities that the people outside have access to ensure that they protect themselves from the disease rather. The inmates do not have those things. And then more importantly, the courts have been shut. There are many cases in prison. Like 70% of the inmates, they are waiting trial. So the courts have been shut. They cannot go to court. Their matters cannot proceed. Their lives are just, the lives of the inmates have remained stagnant since the beginning of this pandemic. You know, take for example, someone who has started trial in courts, and maybe the only thing remaining is for him to conclude evidence, and then judgments will be given. But now the courts have been shut, nothing can be done. So it's affecting them in ways that we cannot imagine.
So what do you think can be done in that case?
Presently, the courts have adopted, though not fully, the virtual court sitting, that is the online sitting, to attend to matters that are very urgent, which is the type that you just asked them. The inmates who are entitled to bail, the court is attending to them, allowing them to file their bail application. And then those ones who have concluded their evidence, the online provision is attending to them, that is judgments or rulings, whatever it is that they,
What do you think is the fate of the inmates at this moment? For instance, we have a case of a person that was trying to perfect bail, but due to the lockdown, was not able to continue with it.
Perfection of bail. The perfection of bail involves the magistrate or the judge would normally call those that to stand shorties to their office, interview them, ask them, the police verify addresses and all of that. All these processes are things that cannot be done for now, because even if you go to court now, most of the courts are shut. Even if you want to present your shorties to the courts, I don't think there is anyone on seats that will attend to you. So those things for now have remained on the same spot, and I do not, I don't think there's any provision now for that. For perfection of the, I'm not sure there's any provision. What we have provision for now is emergency matters. Though not that those ones are not emergency cases too, but perfection of bill is not something that requires sitting. You don't need court sitting. You have already been granted the bill. What is left for you to perfect is by giving your shorties. So for now, I don't think there's any provision for you to say that, okay, maybe you want to go online and tell the court that these are my shorties, 25 million.
On the court system now, with the introduction of the visual system, how feasible or how effective do you think? Do you think the judiciary is ripe and ready for this improvement?
Well, we are not ripe and we are also not ready. But in this case, we are helpless. We need to embrace it. It's not convenient for us. It's novel to us. But we have to embrace it because there seems no other alternative. The pandemic is here. We don't know when it will fizzle out. We don't know when the whole thing will go, and then we can't keep. We don't have a pause on life, so to say. We must evolve new ways of doing things. So, no matter irrespective of the inconvenience that this online sitting is posing to us present, we still have to cope with it. We have to cope with it, though we were not ready. Obviously, we were not ready for it. Like our counterparts in other parts of the world who have been, using this type of online sitting. Our own system is rigid, where you have to be there every time. Pack your books, pack your system and everything. You have to be in court all of the time. But in other parts of the world, it's not every time that you have to appear in court in person. I once listened to one senior advocate who mentioned the fact that he was handling a case in Hague. He has never appeared personally. Whatever his arguments are, files them electronically. Maybe it's just at the judgment stage that he would have to appear in person. He was making that statement at that conference that time that Nigeria, as the giant of Africa, should have developed all this system, because we don't know what will happen tomorrow. Who envisaged that COVID-19 will hit us so suddenly? So the Nigerian justice system does not have a choice now than to embrace this virtual procedures. Although it cannot be 100% effective, but at least let those matters that are urgent, like these inmates, let there be provisions for them to attend to their matters, and ultimately it's even to the advantage of government, because when you congest the prison, at least the little facilities that are there.
Addressing the issue of visual system and looking at the Nigerian Correctional Service, and also factors such as the congestion of the prison, the feeding, and the condition generally, do you think the internet facility or the introduction of the visual system is of priority to the correctional service at this moment?
No, it is. I think it should be a priority. But in this context that you are speaking, even if it is a priority to us, it might not be a priority to the government, because it's the government that will actually make those provisions. For me, the prisons all over Nigeria, if government is really serious and committed to the plight of these inmates, this is something that can be achieved, though it might not be excellent as it is. But I believe every prison should have a common room where they will put, systems and internet facilities and all. And inmates should be informed, okay, your matter is coming up 24th of May or 25th of May. And I think it's the prison officials that are going to be informed because they do not have access to phone. So if the prison officials are informed that okay, so person will sell number this. The problem is we are also poor with data. Because at times you might visit the prison and they will tell you this person is in cell B. They will go there 100 times. They will not, at the end of the day, the person is even in another cell. So I believe if the government is serious about this, about the plight of inmates, every prison should have a common room. It can even be where they receive visitors. Put systems there, might not be more than 5, might not be more than 10, whatever it is, but at least let us see that okay, the government is doing something. And when the inmates are informed by the prison officials that your matter is coming up so late, they should be there in front of the computer there. The lawyer, one lawyer shouldn't be a crowd. Sit beside your client. At least we do criminal investigation. And we go to prisons to visit our clients. Maybe you have a trial. It's not just when the client is in court that you start lecturing your clients, So sometimes we go there, we talk to them, on how to answer questions and all of that. So these things can be done. The government is really committed to it.
Looking at the issue of those awaiting trial, say a person charged for a person that the offense is carrying like say 6 months,
Yes.
But due to the pandemic and everything, the matter could not go on. So now, let's say the person was arrested January, was charged to court, then the matter could not proceed, and the matter is supposed to be for 6 months.
Yes.
What do you have to say in relation to those that are awaiting trial?
Well, those that matters are awaiting trial. Awaiting trial, or they've set the number of years number of months they were to serve for that offense.
They are yet to serve. They are yet to be sentenced. They are still awaiting trial.
They are still awaiting trial. It still boils down to what we've been discussing. If there are technology in place for their trial to take place right there in the court in the presence of their lawyer, I think it would be a good idea.
Okay. Do you think there are other things that can be put in place to accommodate occurrences such as this COVID?
There are a lot of things to be put in place. A lot of things, because we didn't envisage this COVID-19. It came as a serious blow, and we were to a very large extent unprepared. So I think it's an eye-opener for us. There are so many platforms on the internet, Zoom, webinar, Skype, and all of that. So those options are being explored now to attend to court sittings. And then there are other ones that can still be done. Like in criminal cases now, why must I be in court physically to take examination in chief? Examination in chief is my client stating to the court what happened. Like, so day, this is what happened, this is what led to this and all of that. Those ones can be done as something on statement on oaths and be filed in court. Even in tenancy matters, for your examination in chief, you already file your statement of oath. You only go to court to adopt it. So those ones, examination in chief level, you can file whatever your client has to say. The other counsel too can file for the client, and then when it comes to cross-examination, then we can now adopt the online sitting. Because cross-examination involves that you ask questions, the other party responds. It cannot be done just writing. And once that is done, then final addresses can also be filed just like that, and then documents cannot be delivered online. And then another thing is, all this thing boils down to our constitution. Our constitution says that, section 36, public court hearings must be held in public. That part has to be amended. It has to be amended, because even if you get a judgment, for example now, if you file a bail application and the court grants the bail application, or you conduct a criminal trial online and the court gives judgment and it gets to Supreme Court. Supreme Court now throw the judgment out, saying that it has not fulfilled the conditions provided for by Section 36 of the Constitution. Although now, I think the National Assembly is considering amending that part of the Constitution that says that court hearings must be held in public. So if this is put in place, though amendment is also a very, very rigid and cumbersome process, but we have to start somewhere because we need this thing. We don't know when this pandemic will end, and if that part of the Constitution is still there, then the controversies remains. So that part of the Constitution must be amended to accommodate every other thing that we want to do.
On the final note, do you have any closing words or suggestions generally?
I would say that the judiciary, Nigerian judiciary as a whole, it is time for us to start thinking outside the box. It's time for us to evolve new things. Like, we should not just be dogmatic in our ways of practice. Our ways of practice, I think we got it from UK or which country. You know, we got it from them, and they have developed more than 100 years, more than we have here. They don't wear their full regalia like we do here. Although I don't have a problem with the regalia, I don't have a problem with it, but you know, they are so flexible in their own approach. They are flexible, unlike us that we are so rigid, we are dogmatic. You must not do this, you must not do that. Why must I go to court every time to move motionless party? Motionless party is rarely opposed. Maybe I want to move a motion that I should serve someone by substituted means. Somebody that I cannot even see, I cannot locate. How would that person oppose my application? But still, you still have to go to court and say, my lord, this. It's too cumbersome, it's too rigid. And it even wears the judges out. So if you can do with all of those things, I think it makes the job of the judges to be easier. Because a judge has an average of 700 cases to attend to during his or her time of service. More than 700 cases. So you have to develop a new approach to make their job easy. And then if we can do that, then it makes justice dispensation to be faster.
Alright, thank you very much, ma'am.
You are welcome. Thanks for having me.
Yes, ma'am. So thank you to our viewers. Thanks for joining us. We hope it was enlightening and insightful. Also, don't forget to like and share our videos, and also subscribe to our channel. If there are any questions or comments, you can send them in. Also, let's use this medium to introduce our ex-inmate support initiative. This was brought about as a form of assistance to inmates beneficiaries of our legal aid scheme, to impact them and empower them in the little way we can to make them adjust to the society. So we'll be very grateful if we can be a part of this project. Thank you very much.